What is the most important change that the U.S. government has made that will affect every single entrepreneur in the country? Stay tuned. Welcome to this week's edition of Note School TV, and we are happy to have you today. Let's do a few things here before we get started and bring on our guests today. Number one, make sure and like the presentation or like the episode, guys. Just simply hit the like button. If you haven't already subscribed, make sure and do that. And then number three, make sure and bing, hit that bell notification so that you will be notified when every Wednesday at 11:05 when we go live. Also, make sure and keep those comments coming in. Guys, we love to hear from you. Eddie and I really enjoy reading your comments. We learn a lot from what's going on in your area. So please continue to do that as we move forward into 2024. And finally, if you want to know what we do at Note School or more about what we do at Note School, simply go to noteschool.com/TV. Again, noteschool.com/TV. With that, I want to bring on, the Chief Visionary Officer, founder of Note School, my friend, Mr. Eddie Speed.
Good morning, Jeff.
Good morning, Eddie.
Jeff, you're Joe. The guest is Jeff.
It's another one of those J things, right?
You know, when we were started, we were all, kind of preparing for this presentation today, and I'm going to have Jeff come on here in a moment and talk about that. But literally, Joe, this is your opening statement is the truth. This probably is the single most important thing that literally most every entrepreneur I know, period.
Right.
Like whether you're a beneficiary of a trust, whether you're a member of an LLC, whether you're a stockholder, whatever it is, this law that we're going to talk about today is the single biggest thing. When I first heard about this, I was sitting in a session taught by a lawyer, and I text my friend, Jeff Watson, who is our guest today. I text him and I said, "Oh my goodness." And he responded back, "You are reading this right." So you guys, without much further ado, I want to introduce you guys to my personal attorney, and an attorney that a lot of you know. And if you don't, you probably want to get to know him. But he is going to talk about something today that's really important. He will give you his sincere best at painting this picture of something that is really, really going to affect us. You guys welcome Jeff Watson.
Good morning. Hello, Eddie. Thank you for that introduction. And Joe, it's always a pleasure to see you as well. And folks from Note School, it's my pleasure to be with you all. Missed some of you, haven't seen you since Note Expo. Looking forward to seeing you again soon. And I wish I was coming to you with really good, happy, bubbly, cheerful news here with the beginning of a brand new, bright new year. Instead, I'm going to share with you some facts that are highly relevant to everybody that owns and operates a company that has an entrepreneur. And folks, I'm going to flat out tell you, this is going to be the biggest thing to hit the United States economy since the tax code was completely reformed in 1986.
I believe it.
Eddie, this is going to change the way we do business. This is already changing the way I do business, way I'm setting things up with clients and so on. I've been adjusting for this thing for about 120 days. It's now here. It is full on. And the good news is the government is here to help us, and they have no clue what they're doing. They've changed the rules even in the last 2 weeks. But we're going to talk through this. And folks, you got to understand, we're now talking about a law that was slid into a 1,500 page legislation passed on January 1st of 2021. Congress kicked the can down the road by a year or two, finally deciding to make this thing effective January 1st of 2024. Yes. And here we are. So let's get into this brave new world of massive government overreach and intrusion. I don't know how
before Joe and I leave, Jeff, let me say this.
Sure.
I believe that this presentation on our award-winning podcast, voted best in the note industry, I believe it is going to be the most shared, the most looked at and viewed podcast we've ever had. This is if you're in business, this affects you. And Jeff, thank you for your research. I appreciate your diligent effort. Every time you've responded, I've asked you to do something really special. You've always helped us out, and this is going to help out a lot of people. Thank you for this, Dr. Watson.
And Eddie, one quick thing here, guys. This Jeff's going to take about 45 minutes to break this down, so you'll want to stay in there with us on this. So just wanted to let you guys know that. So
Jeff, we'll be back with you at the end. Thank you.
All right, I'm going to do my best to get this in 45 minutes. Everybody, thank you. For those of you that feel so inclined, just ask our Heavenly Father to make sure that the words that come out of my mouth are clear, concise, and accurate, and get the information in a way that everybody understands it, because there's a lot of stuff out here. All right, so getting ready for the Corporate Transparency Act. It's now effective as of January 1st of 2024, and we are in a brave new world. Now, for some of you, you already know who I am, but some of you brand new, or you're watching this thing on replay, you need to understand I've been practicing law now in the state of Ohio for well over 30 years. I am privileged to be general counsel to not only Note School, National Wealth Builders, but the National Real Estate Association, National Real Estate Investors Association, 40-some thousand members across 45 different states. I'm also a co-founder and general counsel to a huge company called RealFlow. I understand that Note School and RealFlow have got some great things going for a lot of you. I'm also a real estate investor. I've been doing real estate investing for over 28 years. Right now, I'm a big kick on subject to deals. I've been doing subject to deals for over 20 years. I love doing stuff in the self-directed IRA space, but most importantly, more and more people come to me for guidance on how to stay compliant with big, new, drastic, sweeping changes. And that's what we're going to talk about today. Big, new, drastic, sweeping changes. So to give you a perspective of where I am in the compliance space, I've changed the law in the state of Ohio 5 times, 4 times litigation, 1 time in legislation. I've changed national housing policy not once, not twice, but 3 times. I have been working with Eddie Speed and David Finolio and Mike Powell and so many of the other members of the amazing Note School community to get an amendment passed to modify Dodd-Frank, the SAFE Act, and Truth in Lending to enhance seller financing. We've been working on that. We just did a congressional meeting in the last few days with a staffer for a New York Dem. 2008, I revolutionized short sale transactions. That took me from being a small town country lawyer to somewhere that people wanted to hear what I have to say. I'm a member of the board of directors of Quest Trust Company. Every time I say it, I kind of like pinch myself to believe that's really true, because it's a huge honor. And then I've got a couple of real estate clients that are entrepreneurial so well that they've made the Inc. 500 list. In fact, RealFlow made the list 1 time, and I've got 1 client that made it 2 years in a row. All in the real estate space. So I have to tell you, because I'm a lawyer, I got to do this disclaimer. First of all, I'm licensed to practice law only in the state of Ohio. Everything I'm doing today is not legal advice. I'm giving you some education. It's designed to provide both accurate and authoritative with regard to the subject matter, but this is education, folks. I'm providing it with the understanding that the presenter is not currently engaged in rendering legal, accounting, psychiatric, or other professional advice. And yes, psychiatric advice might be sought after this presentation. If legal or other professional assistance is required, the services of a competent professional must be acquired. Now, getting a competent professional who's up to speed on the Corporate Transparency Act is going to be few and far between, because, folks, they keep changing the rules and we're grappling with it. It's kind of like the PPP loan program, where the rules changed every day for a long time and we had to pay attention to it every day. So as a real estate and note investor or operator, you have got to be ready. You've got to know which of your entities that you already have, LLCs, S corporations, C corporations, partnerships, what you have right now, which ones of those are considered reporting entities under the new Corporate Transparency Act. So the first thing I want you to do is you need to say, okay, I have to be responsible and make a list of every entity that I have currently established and own. And then you need to understand who are the beneficial owners of every one of those entities. Is it just you? Is it you and your spouse? Is it you and a partner? Is it you and some of your kids? What is the mix and match? You need to know who they are. And then you need to know who has substantial control over that entity. And then you need to make sure that you timely file your required disclosures online with the Financial Crimes Enforcement Network. Now, that website is open, up, and functional. So it's there. I've gotten on the website. I've started to fill out some stuff on it. It's 4 to 5 pages long. It's tedious. It's cumbersome. It's extremely invasive. I would just flat out say it's the nosiest thing I've ever been asked to do regarding my entities. Okay. You need to know this stuff. It's not fun, but this is coming at us. Now, I'm going to tell you, this is a compliance statute. But the federal government has, through its infinite, aggressive, all-consuming, all-knowing, all-powerful decision-making, turned lawyers like me into extensions of their enforcement mechanism. And if I don't do certain things, I can face penalties and fines. But more importantly, if you don't do certain things, you can face penalties and fines and imprisonment. Yes, up to 2 years of imprisonment for failing to report what entities you own and who you're involved with in those entities. First time I've ever seen a felony component to failing to report. Now, I understand a felony for failing to file and pay taxes, but I don't understand a felony for not reporting. But that's where we are. So this Corporate Transparency Act aims to ensure that reporting companies identify all individuals with both substantial control, which is a very interesting definition we'll get into, and all of those who own or control directly, indirectly, through intermediaries, through stacks, through layers, through anything out there, own or control at least 25% of the ownership interest of a company. They want you to report it in your beneficial ownership information report. So there's a whole new vocabulary that we have to learn. The words in the Corporate Transparency Act do not mean the same thing what they mean in other areas of the law. So we've got to learn what they mean when they say this. There's a vast and significant learning curve. So anybody who tells you that they've got their arms around this thing is telling you that they're hugging an elephant's hind leg and they think they're riding the beast, because they ain't. Okay? There's a lot coming and we're still figuring it out. So let's talking about beasts. Let's get clear. I'm going to give you some strategy. I think all of us at one time or another have seen video images. We've watched the documentaries of the vast wildebeest migration across the plains of the Serengeti. And we have seen where these huge, thunderous herds come up to these big crocodile-infested rivers. And eventually the wildebeest have to cross, and the crocs feast. And I'd hate to liken our federal government to crocodiles, but I don't know what else to say here. But if you come too soon and you make a mistake, you could get pulled under and eaten alive. If you fail to comply, you're going to get eaten. You're going to be prosecuted. So my recommendation is, for the next 60 to 90 days, do not panic. Get serious, get prepared, get informed, get educated. But we don't have to do anything yet unless you fit one small exception. And I just fit that exception yesterday on one of my companies. So I'm going to be one of the guinea pigs that's going to be somewhere in the second wave of animals crossing the river, and I'm going to have to be careful that the crocs don't get me. Okay, so I'll be able to come across to report how it is. So let's talk about this. If you have an entity that existed as of December 31st, 2023, and when I say an entity, I'm talking about a single member LLC taxed as an S corporation, taxed as a C corporation. I'm talking about a single member LLC that is a disregarded or flow through entity. I'm talking about an S corporation. I'm talking about a C corporation. I'm talking about a partnership. I'm talking about anything like that. I'm talking about anything like that. That type of entity must report by the end of 2024 who its owners are and who has substantial control. Those two things must be reported. And if you're going to think, well, I'm just going to give them my initials and I'm going to give them P.O. box as my address, ixnay, no way, forget it. They want a photocopy of your driver's license, a color copy of your driver's license, or your passport, because they're going to go off of your passport number or your driver's license number. And they want your physical street address where you sleep at night. Where are you registered to vote? Where's your driver's license come back to? What's that physical address? That's what they want. They don't want P.O. boxes. They don't want drop boxes. They don't want business addresses. They want home addresses. Now, for the business, they want the actual main business office. That's what they want. They don't want P.O. boxes. They're very clear about that. They will not accept that. They want the physical address where they can show up if they need to. All right. We're going to get into more of this. So let's first begin to understand who must report. Everybody to whom I'm speaking with. If you own an LLC, if you own a corporation, you must report what you own. Not what the corporation owns, not what the LLC owns, but you have to report what you own. If that entity has $1,000 or more to its name, it must report. And all owners of 25% or more of that entity must report who they are, where they live, provide government issued photo ID to go along with that. So if 4 of you have gone out and set up an LLC to do note deals, all 4 of you are going to have to report that you own that LLC. It's that simple. If you've got a single member LLC, just one of you is going to report that, and you're going to have the benefit of being both substantially in control and being the owner of it. So we're all good there, okay? Now, those who have substantial control over an entity with $1,000 or more of assets. Now, substantial control is a very interesting term in the Corporate Transparency Act. I think it is vague. I think it is like trying to nail Jello to the wall. I know that there's at least one good pending court action in North Alabama on this issue. I don't know where that case stands right now, but this is a very, very interesting definition that we're going to have to work through in a minute. So you do not report what is owned by the entity. Instead, you have to report who owns the entity. So privacy as to what you own is gone. So all of anybody who went out there and bought into the Nevada corporate headquarters nonsense or bought into the Anderson Advisors business nonsense of, oh, we're going to keep your identity protected. Nope, not anymore. It's now going to be on a government database that any law enforcement agent that can bluff their way on and come up with a reason, they're going to be able to dig into it. Now, you and I both know what happens with anything that gets put on a government database. Let's be serious. I don't care if on page 21 of the 22-page bill, they talk about how important it is for cybersecurity and that they're going to treat this as the highest degree of non-classified information. Folks, let's face it. The North Koreans, the Chinese, the Russians, the Ukrainians, the Bulgarians, the Romanians, and a bunch of other people from all over Africa and South America have hacked into all sorts of different government databases and stolen reams, trillions of bytes of information. Whatever gets put up there is going to get stolen. It's going to get hacked. It's going to float out there on the dark web. And I'm going to tell you right now, buy identity theft insurance. You're going to need to buy identity theft insurance. I already own it. In fact, I've got 2 different policies because I am that paranoid about making sure that when somebody does steal from me and they try, I'm covered. Now, the database is purportedly not public and only available to the law enforcement. Purportedly, I say. not public and only available to law enforcement. I believe otherwise. I believe that it is going to be abused and it is going to become a hunting ground for the Criminal Investigation Division of the IRS. I believe that the big data from the IRS is going to get merged with the big data from FinCEN, and they are going to have a field day tracking down scofflaws and tax cheats. Okay, there's my thought. Trying to be a little humorous here, folks. Just trying to have a little bit of sarcastic humor. If you work for the federal government, my apologies. I have nothing against you personally. I just know that it just, folks, it just rises to the lowest common denominator, and we'll go from there. All right. So I'm going to be serious. This is not a sales pitch. This is just legal. This is not legal advice. This is just one friend to another. Prepare now for identity theft. Identity theft has been an issue for a long time in this country. I've had it happen to me. My mom's had it happen to her. My uncle's had it happen to him. I've seen it over and over and over again. There's scammers. There's all sorts of spoofers. It's all sorts of crazy things out there. Prepare for identity theft now. Buy ID theft insurance. Don't buy credit monitoring. Buy ID theft insurance. Now, I buy from 2 different companies. I'm not going to pitch you on those companies. I'm not trying. I'm just going to tell you I have 2 different policies because I want to make sure I'm nailed down. Okay. It's just kind of like why I have a liability policy and an umbrella policy. Okay. I prefer ID Seal. It's faster and more comprehensive monitoring and notifies me within 24 hours if my social security number has been used in a business transaction or credit application. I don't make any money by telling you the name ID Seal, but I just did tell you the name. I don't make any money. Now let's get into the definitions. By now, I've done one of 2 things. I've gotten your undivided attention through fear or curiosity, and you're paying attention, or you have done what so many Americans do, which is which is we just want to pretend it doesn't exist. It's more than we can handle. We're going to do the ostrich thing. Okay, we're going to pretend like we're the 2-year-old and we're going to cover our eyes and we can't see the problem anymore. Don't do that route, folks. Okay, hang with me. Hang with me. We're going to get into this. I'm going to walk you through it. I'm going to give you some definite things to do. I'm going to give you some things not to do. Okay, well, let's get into this. Ownership interest. Somebody's going to say, well, Jeff, I think there's probably some loopholes that we can exploit. Well, let me put it this way. Ownership interest is very broadly defined under the Corporate Transparency Act, and it encompasses various instruments and methods of ownership, including, but not limited to, equity of 25% or more. If you form an LLC and you own 25% or more, you got to report that beneficial ownership interest. Well, okay, well, Jeff, I'm only going to own 24%. Okay, we'll get to that. Certificates. Say you've got the certificate on demand, a warrant where you could switch your loan to ownership stake. That needs to be reported. Let's just say that you have an interest in a joint venture and the joint venture owns the LLC. So there's a cut. You're thinking the joint venture is a cutout between you and having to report. Nope, doesn't work. They're going to look right through the joint venture. They want to see the participants at the end. Well, Jeff, I'm going to own my LLCs through a trust, and that trust is going to be owned by another trust, and then that trust is going to be owned by this single member LLC, and that single member LLC is going to be owned by this third trust, and then I'll own that third trust. Folks, they're going to cut right through all of it. They're going to look right through every one of them, and they're going like, we want to find the actual flesh and blood, beating heart human being. That's what we want. We don't want the name of another company. We want a date of birth. We want a passport. We want a driver's license. We want a physical street address. Convertible instruments. Oh, well, Jeff, I've structured this LLC to where, I don't own it. Someone else does in name only. They're a proxy. They're my agent. It's kind of like MERS. You know how MERS works, Jeff, where the MERS is the nominee, but well, folks, guess what? If you have the right to make the decision, we'll get into substantial control. They're going to want your name, address, picture, etc. Okay? If you use trusts, they're going to look right through the trusts. I'm going to put it out here right now. I'm going to be very clear. If you have a trust where you have formed the trust as a human being, your next best friend as a human being is the trustee, and your kids are the beneficiaries, that trust like that does not have to report. But go have fun getting a bank account for that trust. That'll be a real joy. You'll wish you'd gone an LLC and filed with FinCEN instead of trying to get a bank to give you a bank account for that kind of a trust. Just saying. Okay. Equity pledges. I believe that certain types of equity pledges, and I've drafted a few of them now these days, they could trigger where if that pledge holder starts to direct operations, that pledge holder now has 30 days to report themselves as either having an ownership interest of 25% or more or substantial control. See, there are very fact-specific events that can occur in the operation and the day-to-day operation of a business that may trigger the application of the Corporate Transparency Act. So do not count on your tax preparer. Do not count on your enrolled agent. Do not count on your accountant. Do not count on your business advisor. Do not count on your insurance agent to know these things. You had better find an attorney that understands this stuff. And folks, I can tell you right now, there's not many of us out there. And the ones that I know, we're talking every week about what do we see, what we're doing, what we think. Ownership interests. An individual may own or control an ownership interest through various means or methods, such as trusts, beneficiaries, grantors, intermediaries. So let's do it this way. They have the specific language in the Corporate Transparency Act says, we think you're going to try these games and we still want to know who's behind these things. We want to know who are the beneficiaries, who's behind this. We want to know all this stuff. We're not going to fall for this game. This is incredibly invasive. This is very, very, very nosy stuff that they're looking for. Now, this is how the CTA looks through a structure. Now, I've designed this structure for hundreds of real estate investors across this country, where we take a piece of property or we take a note and we own it in a trust. And the trust is owned by an LLC, and that LLC is owned by a multiple member LLC, and that multiple member LLC is now owned by you, the spouse, partners, etc., and so on. Okay, this structure still works, but this structure now requires that this LLC report, this LLC report, and this LLC report, all three of these LLCs must report, and these are the people who have to make sure that it reports, and the control of it has to be reported, and the ownership of it has to be reported. Now, these trusts do not need to be reported, but these trusts are owned by LLCs, which are owned by another LLC, so it's all reported, okay? The good news is we don't report what the entities own. Instead, we have to report who owns the entities. Understand that now we're getting this side of the coin. The IRS has already had the other side of the coin. And so when they smush them together, there ain't no secrets out there anymore for the tax man and the federal government. They'll be able to put it together. Now, let's talk about what substantial control means, because this is a very different definition. If some of you who have been out in the private money space and you've been out raising money in the capital space, you might have come across a different definition of substantial control. That definition does not apply to the Corporate Transparency Act. Instead, substantial control means the following. Do they serve as a senior officer of the reporting company? Are you a manager of an LLC? You have substantial control. Are you a manager of a partnership? Are you a co-general partner of a limited partnership? You have substantial control. Okay, next. Do you have authority over senior officer appointments? Or do you have authority over the majority of the board of directors? Well, Jeff, I don't own any of the company and I'm not a senior officer, but I'm the dude in charge that everybody knows is in charge. And so when I walk in the room, everybody pays attention because I can hire and fire, I can appoint and, remove senior officers from their duties, and I can make sure who serves on the board of directors and who doesn't. You have substantial control. You have substantial control. I don't care if it's not in paper. If it's in reality, you need to report it. If you influence important decisions. Now, think about the vagueness of just those three words: influence important decisions. What's influence? What's important? We can kind of agree that a decision is to do something. Sometimes a decision to do nothing is a decision. But influence important, those are so vague and wide open. But influence important decisions, including those related to business operations, asset transactions, equity issuance, debt, contracts, governance documents. Let me boil it down. If you have the decision in an entity, a corporation, an LLC, a joint venture, whatever it is, a partnership, if you have influence on what notes to buy and how to price them and what to do with them, you have substantial control. If you decide what properties get rented at what price, you have substantial control. If you decide who hires the handyman and the maintenance people, you have substantial control. If you decide what houses to buy or not buy, if you decide what marketing operations to run, if you decide what advertising to run, you have substantial control. Do you follow me? This is very big, but it's vague. And because it's so vague, it's so big. We have got to understand that they are looking under every They're looking under every bed. They're looking at all the corners, all the cracks, all the nooks and crannies. They want it all. All right. So let's talk about the term beneficial owner. Okay. A beneficial owner means with respect to an entity. An entity can be a single member LLC. It can be a multiple member LLC. It can be a C corporation. It can be an S corporation. It can be a joint venture. It can be a partnership. A beneficial owner means with respect to any of those entities, an individual, which means a human being, who directly or indirectly, through any contract, arrangement, understanding, relationship, or otherwise. You got the idea how vague and broad that is? Exercises substantial control over the entity, or owns or controls not less than 25% of the ownership interest of the entity. You say to yourself, well, Jeff, I only own 24% of the company. And my kids and my spouse, they own the remaining 76. And since I have 6 kids and 1 spouse, we split the other 76 among all of them. And so they all own about, 12, 13% each, whatever the decimal is there. Okay. Yeah, but who tells the kids what to do? Oh, my kids aren't minors. Do they live with you? Are they economically dependent on you in some way? Who ultimately makes the shots? Okay. Well, no, Jeff, none of us own more than 25%. We're all adults. We don't all live together. My kids are all adults. We come together when we make all the decisions together. Great. Well, then you all have substantial control. You're still going to have to report. Beneficial ownership does not include a minor child, as defined in the statute when the entity is formed. But when the child becomes an adult, they have to report. It also does not include an individual acting as a nominee, intermediary, custodian, or agent on behalf of another individual. You see, get this part. They don't want to know who is the nominee. They don't want to know who is the cutout. They do not want to know who is the intermediary. They do not want to know who is the consigliere. They do not want to know who is the custodian. They do not want to know who is the agent. They do not want to know who is the runner. They do not want to know who is the buffer. They want to know who's in charge, who really ultimately owns it. That's what they want to know. And so you say, well, Jeff, I'm going to set the entity up where I'm going to have corporate nominees and I'm going to have trusts in there and so on. They don't care. They flat out are telling you in the statute they don't want that information. They want to know who you are and what you own entity-wise. Okay? So beneficial ownership does not include an individual actually acting solely as an employee of a corporation, limited liability company, or similar entity, and whose control over economic benefits of such entity are derived solely from the employment status of that person. So in this audience, I'm going to give you an example of someone who has a lot of authority, a lot of responsibility, but fits this definition, and that would be Susan De La Garza. She's an employee. She benefits from employment and bonuses, but she doesn't own any part of the company. But so Susan would not have to report. Eddie and Martha would have to. It's that simple. So you look at your companies and you say, well, I look at my companies, okay? My boss is Debbie. Debbie DiPolito is my boss. She's my main assistant. Without her, my world would crash and burn in 40 seconds or less. But she's not an owner. She's an employee. She tells me what to do in, between us, but I'm solely responsible at the end of the day. So I have to report, Debbie doesn't. It's that simple, okay? Now, beneficial ownership does not include someone who has yet to inherit, okay? An individual whose interest in a company, limited liability company, or entity is only through a right of inheritance, which means they have not yet inherited. They will, and when they do, then when their inheritance becomes vested rather than incohate, to use a couple of terms that other lawyers might understand, when their right to inherit, when their right to the company is vested in them, then they have to report as an owner. And they'll have 30 days to report. Not 90, not the whole year. They'll have 30 days. Yes, that's an ouchie. That's the rule that I bumped up again yesterday when a partner and I bought another little company. Now we've had a change in the ownership of the company. We're in 2024. I got 30 days to report this. Okay. It does not include a creditor of a corporation, a limited liability, or similar entity unless the creditor meets the requirements of subparagraph A. And this was a loophole that I thought I could squeeze some stuff through because I was like, well, Jeff, we're gonna just take and move the membership interest off to somebody else in a pledge format, and then they're not gonna make the decisions. I'm gonna continue to run the company. And then I looked at it and I go, it still fits the definition under subparagraph A. Can't do it. Looked at it, thought about it, got serious about it, looked at it for a good day, thought about it. Nope, can't do it. They've closed down every conceivable loophole I've dreamed up over the last 90 days of looking at this statute. Now, here's the thing that's scary. It's important to note that these exceptions are not absolute, and some of them may cease to apply under certain circumstances. Yes, that's right. Can you imagine the rules changing for the benefit of the government? Oh, I can. Happens on a regular basis. Happens on a regular basis. Eddie, think back to some of the times that you and I have been in Washington, D.C., and how at certain times it's really difficult to get into certain government buildings. And other times it's not so difficult. Anything change? No, just the whim of somebody who has authority in Washington, D.C. makes it easier or harder for you and I to get to some of our meetings. I mean, the last time you and I were in D.C. together, we had to cancel some of our meetings because of some protesters, Why? Because they closed down one of the House office buildings. So certain circumstances change and the rules are going to change. So you got to be flexible. Do not think that you're going to find some way through this. All right. Now, let's talk about this. So you've got an existing entity. You're looking at me and you're going, Jeff, you've scared me to death. Jeff, what do I do? For an existing entity, one that existed as of December 31st, 2023, the final rule requires that that company report by December 31st of 2024. For existing entities, we've got 1 year from the effective date to report that. That is great news for a couple of reasons. Existing entities only have to report. They've got a year to do it. They only have to report who has substantial control and who are the 25% or greater direct or indirect owners, beneficial owners. Okay, that's the easy part. So everybody who has an entity that existed before January 1st of 2024, you got a year to comply. So then I'm going to go back to my analogy with the herd coming across the Serengeti. You got a year. Let's not be in the front wave of the herd. Let's not be at the tail end of the herd. That website is going to crash. I predict that website is going to crash in December of 2024 because there are about 25 million businesses that are going to need to report. And you know how entrepreneurs are, about 20 million, we're going to wait till the last couple of days and they're going to crash that website. So we want to be doing our stuff probably in the end of May, beginning of June, when things are kind of slow government wise. That's when we want to report. That's when the website should be functioning. All the bugs should be worked out. Most of the rules should be cleared by then. And that's when we want to report. Okay. For anybody that's got an entity that it was existing prior to January 1st of 2024. Now, the statute established a maximum 2-year period to do this, but FinCEN, in its regulatory wisdom, came back and said, we're going to do it in 1 year. We think that we can create a website that is going to gather information and store it in some sort of massive database for between 25 and 35 million entities. And we think it will all happen within 1 year. I admire their optimism. Do I think it's going to work? No, I think that website's going to crash in December. And, you know, if you waited till then, shame on you. I think you got to get in a little earlier. All right. Now, for newly created entities. So you're like, okay, Jeff, I didn't know anything about this. I didn't pay any attention to your emails. I didn't see the other stuff you did for the Seller Finance Coalition fundraising event back on December 14th. I didn't see that. I was not a good supporter of the Seller Finance Coalition. I didn't pay attention. Jeff, I went ahead and I set up a new entity on January 3rd. What do? You got 90 days to report. You got 90 days to report. You got 90 days to report. If you set up a brand new entity, you got 90 days to report. Now you have to report 3 things. You have to report 3 things for a new entity, not 2, but 3. You have to report who are the beneficial owners. You have to report who has substantial control. And you have to report who is the applicant, who helped you create the entity. Then now there is a burden on attorneys in particular on creating new entities. This is a huge challenge. So this is something that is causing me to really rethink how I practice law, what I do. If I helped you establish an entity in the past, with the entity that we set up in the past, I'm still around to help you. You come to me now and you say, Jeff, I need a new entity. We're going to be pumping the brakes. Slow down, buckaroo. How well do I know you? How well do I know you? Do I trust you? Do I believe that what you're telling me is the truth? Because I'm not going to stick my neck out on the line for somebody that I don't know, somebody that I don't believe, and somebody that I don't trust. Okay? Now, any entity created prior to January 1st of 24 does not have to submit company applicant information. Any entity created January 1st of 2024 and thereafter must submit company applicant information. This is substantially changing my law practice. This means that any entity created after January 1st of 2024, who are the owners, who has control, and who helped set it up, all that has to be reported on the FinCEN website. That's pretty onerous. I look at this, looking at the website, looking at how long it normally takes me to go online with various state government agencies and file LLC documents or whatever. This is probably now going to take what I used to do in 10 minutes. It's now going to take me an hour. Yeah. Is that going to change the way I practice law? Yeah. Is that going to make my prices go up? Yep. Sorry. Okay. Reporting companies will only need to report the fact that they were created and registered prior to the effective date and the information required for reporting companies on beneficial ownership. So this is where I was talking about before December 31st, people. This is all you got to do. After January 1st, people, you got a lot more to worry about. Okay. Now, for a reporting company with a principal place of business in the United States, the reporting company should provide the full name of the owner, the physical street address of that principal place of business, not a P.O. box, not a mailboxes, etc., not a UPS store. Where can the SWAT team roll in from? That's what they want. and they want a copy of a government issued ID, driver's license or passport. So please make sure it's up to date. A government issued passport or driver's license. Make sure your ID is the more compliant version of it too, okay? They're going to need to see that. Now, reporting companies will not be allowed to report a DUNS number or an LEI number in lieu of a taxpayer identification number. You're going to need to go get a taxpayer identification number or an employee identification number, an EIN or a TIN from irs.gov in order to comply and report. This is going to make it a little more tricky when you do that, because some of us got cute and we were able to, fool that website and send them to mailboxes, etc., into UPS stores and so on. Not anymore. Okay, you might be able to get away with it on the IRS website, but FinCEN is going to know what it really is. Okay, now FinCEN decided to extend the time for filing an initial report for new entities, for newly formed entities, to 90 days because they want to make sure that everybody has time to get a taxpayer identification number before filing. That's fine. It's not that hard to get an EIN or a TIN before filing for most new entities. It's not that difficult, unless you've got some problems with your tax records in the past. But folks, it's really simple. You got 90 days from when you set up your LLC and you expect to do business to get your taxpayer identification number and file with FinCEN. And oh, by the way, you can't get a bank account opened up without a taxpayer identification number. Oh, by the way, you really aren't legally a business until you have filed your articles of organization, filed whatever you got to do with your state, you've adopted the operating agreement or the bylaws, you've opened up a bank account and held your first meeting. That's when you're really an entity now. In order to do all that stuff, now we've got to add one more thing to the process of, oh, have we done this? Yes. Have we done that? Yeah. Have we scheduled the first meeting? Yes. Have we adopted the operating agreement and the bylaws? Yes. Well, now have we gotten taxpayer identification number? Yes. Well, now is the clock's ticking on filing with FinCEN. So there's just more to this stuff. So you're going to need to be using wise professionals on setting up your entities going forward. Now, let's be clear. The final rule revises a provision to require clarity. A business address is required for a company applicant. That means I have to, when I form an LLC, on behalf of a client, I have to report my physical business address, i.e., where somebody can show up, knock on the door, and walk into my office. Every time I set up a new LLC or a new company for somebody else, I've got to report who I am, where I do business. That's a challenge. Okay, so going forward, less is going to be more. I don't think we're going to see this mass wave of, oh, I need a trust and an LLC for every deal I ever do. I don't think we're going to see that. This is going to pare it down. You're going to see a lot of entities get dissolved. You're going to see a lot of entities go quiet, get canceled, shut down, cease to do business, and so on. All right. There's going to be fewer LLCs and corporations in order to reduce the risk of non-compliance. The last thing I want to have happen is for one of you people to be politically active in a cause that's not popular with Washington, D.C., and fail to report this little LLC you had sitting on the side that had a couple $1,000s in a bank account you kind of sort of forgot about, and then they come at you at $500 a day for non-compliance, and if they really don't like you, they're going to go after you and try and see if they can get 2 years in prison for it. So this is the time to take inventory. This is the time to really be thorough. Look through all of your records. Think about everything you've got. Go on and search the various Secretary of State's websites. Some of you serial filers out there that you're going to set up a Wyoming company to be owned by a Nevada corporation, to be then run through a Delaware organization. All that chicanery has got to end. They're seeing through it. Okay? I think we're going to see much greater usage of personal property and title holding trusts. Much greater usage of that. I'm prepared to go forward in that direction, and we can talk more about that at some other time. Eddie, I think back to a time when Note School had an event in Las Vegas where David Fenoglio was so generous regarding this. We raised money for the Montague County Child Welfare Board. I spoke, some other people spoke all about trusts and so on. That was a fantastic event. That stuff's going to come back more and more. All right. How am I changing my business? I'm only working with individuals that I know. If I don't know you yet, I'm going to need to get to know you. Okay. I'm only forming LLCs right now in the state of Ohio because I don't want to be playing in other states until I really understand what's happening. I'm having to raise my prices in order to accommodate the extra risk and responsibilities that are out there. Your plan of action: identify every LLC and corporation in which you have an ownership interest or with which you have an affiliation. Verify that each of those entities has its own taxpayer identification number. Every entity that has $1,000 or more of assets that it owns or controls must report in 2024. Make sure you've purchased identity theft insurance. Folks, if you can, screenshot this image right here. This is your checklist. This is what you need to do in order to be compliant in 2024. Screenshot it. I'm going to hold it there for a second longer, and then time is running out. I got to keep moving. 3, 2, 1, screenshot it. Moving on. Understand who must report. Owners of 25% or more of entities with $1,000 or more in assets, you need to report. Those who have substantial control over an entity with $1,000 or more in assets, you need to report. You do not report what is owned by the entity. The IRS is already figuring that out. You have to instead report who owns the entity. So now they can match it up. Two sides of the coin, both halves of the sandwich, they got it together. All right. When it comes to reporting in 2024, timing is everything. For an existing entity, do not register it for the first 4 months of 24. That's my recommendation. Let's let the bugs get worked out of the system. Let them develop all the rules. Let the big part of the herd get across the river. Make sure the crocodiles are all well fed. Let them get the bugs worked out. And do not wait. Please, please, please do not wait until the end of 24 and get caught in the mad rush to beat the deadline. I know how entrepreneurs are. I know how you people think. I love you. I love working with you. But sometimes you just drive me crazy because you wait until the last possible second and you're looking for an extension even then. Do not do that. This website will probably crash. Remember, this website is designed to hold a lot of information on between 25 and 35 million entities. Now, if we take 365 days and we divide it into 25 million entities, that's a lot of entities per day that need to be reporting. Do not wait until December. Now, this database is purportedly is not public, and is only available to law enforcement. You know what I think about that? Yeah, right. So I'm going to tell you this strategy. Now, I'm going to put this up. So somebody's going to say, well, Jeff, here's my complicated structure. What do I have to report? You and your partner, or you and your spouse, are going to need to report the ownership of all 4 of these LLCs. All 4 of these LLCs are going to need to be reported. This is an illustration for how people might own notes or houses or whatever. You and your partner or your spouse, because both of you have control or 25% or more greater ownership interest, you're going to need to report your ownership of this company and these other LLCs as well. You're not going to have to report the trusts. All right. Those are the ones that must report. There you see it circled. With that, I think I'm right to the balance of my time. And so I'm going to just tell you thank you. Those of you that want to follow up, you can do so at watsoninvested.com, watsoninvested.com. And with that, I am going to, at great personal risk, click the stop sharing button. There. So we've brought it in. I hope I didn't go too long. And with that being said, Joe, Eddie, whoever wants to take this thing back over, please be my guest.
Well, that was excellent, Jeff. And I really appreciate your practical application because you have represented a lot of real estate investors. So you know how we think, right?
I is one. I know how you think.
And so we're always going to outsmart the system. And thank you for pointing out the obvious. Joe, one obvious thing is, Note School is a note investing school, whether you're creating your own notes or whether you're buying notes. Right. Anybody that owns any kind of entity, this all applies. This is no special thing for real estate investors. It applies to anybody that owns any form of business whatsoever. So, Jeff, I think you made that clear. I'm just going to make that, we'll call that Captain Obvious, right?
Yeah.
One of the things that I think is important is, Jeff, you alluded to the fact that they are developing the rules right now. And so just quickly tell us what that means.
It means that, well, there's two things going on. They're still interpreting and applying the rules because they're not sure what all they mean, because we started out with a 22-page bill that was part of a 1,500-page bill. And then we handed it off over to the bureaucrats, and they came up with 99 pages of how they interpret the rules. You get an idea where this is going? So now they changed their mind. My good friend Dykes Bodiford, folks, if you don't know who Dykes Bodiford is, you need to pay attention to Dykes, assets101.com. My good friend Dykes Bodiford pointed this out to me. In fact, Dykes has come and spoken in Dallas at your audience, Eddie. You remember that.
Mm-hmm.
Yep. Dykes pointed out to me that one of the 30-day rules got changed out to 90 days because they realized just how unworkable it was. So I expect to see more things like that changing. However, they're still figuring out how things work. There's a lot of things we don't know yet. Whether we get a FinCEN number or not, whether I may end up with two FinCEN numbers. I may end up with one because I own businesses, and I may end up with another one because I'm an applicant, i.e. an attorney that sets up other LLCs for other people. So we don't know these things yet. So hang loose, stay cool. Right now, there's no need to procrastinate, but there's never need to procrastinate, but there's no need to panic. Instead, let us figure some more stuff out, but do your homework. Like the one slide I told you to take a screenshot of.
Yeah.
Y'all got some homework to do. I know how you guys think. You're going to say, oh, I'll get to that next week. Yeah, well, next week's going to come and go and be long gone before you think about it again. You need to identify every entity you've got. Let me go through this. If you've got a joint venture with a bank account, if you've got an LLC, I don't care if it's a single member. I don't care if it's a multiple member. I don't care if it's disregarded, tax as a corporation, tax not. I don't care. That LLC, if it's got $1,000 to its name, if it's got a bank account, if it's got a tax ID number, you got to get it on your list. If you're in a partnership, if you're in a corporation, whatever it is, you got to get these things listed out. And some of you are going to have a page and a half of names for all the entities you got out there. And for every one of them, you're going to have to figure out, what do I need in order to report this thing? Well, who are the other owners? Who has substantial control? Do I have their identifying information? Do I know where they live? Do I know where the business is headquartered? Do I have photo IDs, passports, driver's licenses? This is a massive administrative burden being dumped on the shoulders of the tax-paying, revenue-producing segment of our society and culture.
Jeff, let me say this in kind of conclusion. Just an entrepreneur that I'm probably one of those guys that has a pretty long list, right? As you well
Probably
know.
So.
There's going to be a lot of myths. There's going to be a lot of people on Facebook that are saying stuff, masterminds. And let me just tell you something. This is not something where you want to get bad advice or advice of a maverick. Okay? This is not maverick. This is not how to close somebody at the closing table, right? This is like real stuff. Don't operate with myths, right? The way you're not going to operate with myths is you're going to have reliable attorneys and reliable accountants. And just because they have a license doesn't mean they're competent. Okay. You're not saying that, Jeff. I'm saying it. I've met a whole bunch of incompetent attorneys and accountants. Just because they passed a test doesn't mean they got any sense. So I want somebody with some walking around sense.
Yes. Yep.
Right. And this is really important because their mistake becomes your problem. Bad advice is the same as, they ain't going to go to serve your prison term for you.
That's right.
And so I'm just saying, as an entrepreneur, and believe me, I have a lot of life experience in this, as Jeff Watson knows well. The last thing I want to say to you guys is you are not too small to ignore this. Right? You could be too big to ignore it, but you are definitely not going to be too small.
Jeff, one quick thing. What about people that say, okay, well, I'll just do a sole proprietorship and file a Schedule C?
Okay, so they're a sole proprietor, which means they're doing business in their own name.
Right.
They have no entity, they have no business, they have no liability protection.
We're just filing a
They-
Schedule C pass through to their 1040.
Yeah, they're taking a risk. They're running business. They're doing business naked. They
Yep,
got no
absolutely.
liability shield. God
In
bless
many
if that's the
different
way they
ways,
want to go.
right?
That's probably ill-advisable, but
Yeah.
but that probably means reporting is not the problem.
Right.
The not reporting is the problem.
Correct.
Correct, Jeff?
Yeah.
Right.
So if you don't report, that is a $500 per day per entity penalty, and up to 2 years in prison.
So why don't we do this? Why don't we maybe revisit this, Jeff, in this venue here in June, mid-June, 1st of July, and just kind of remind everybody where we are.
Yep.
Jeff, I'm going to ask for two things, and I haven't asked for this, so this is really live TV because it could only happen this way, right? First of all, I want you to give us your slide deck because you had some good information in there, and if we can get your permission, I know there's a slide deck that animates a little bit. If you could give us both versions, the first version and then the animated version. There also, FinCEN also has a white paper. It is a moving document.
Yes.
But it is pretty well written. We can include that that white paper document. And once again, it's not, the guidance rules are changing. So don't think just because FinCEN's white paper said it in January doesn't mean that that's all that it can be in April, because it may not be, but at least it's better than a blank sheet of paper. Jeff Watson, you have done a terrific job of really doing something to no personal benefit of your own. You've done it for the benefit of the industry, which I've seen you do over and over. We appreciate that. This is Note School's heart. We're not trying to sell you any training. We're not trying to do anything other than the fact that it affects my business. It affects my family, my friends, Joe the same way. And we're just trying to put the information out there. I hope this has been of value to you guys. Yeah.
Well, I hope it was a value too. And Eddie, I will in the next 10 minutes email the slide deck that I just used. I'm going to send it to Susan. Let's send it right to where it matters. We'll get it to Susan. The white paper that you and I have talked about, that you shared with me, I think that's a great tool for people to look at.
Yep.
And the last thing I want to tell people is, please, please do not ignore this.
Yeah.
And the advice that Eddie gave you is very consistent with what I said. My advice to you is, I want you to be in the center of the herd of wildebeest going across the river. Don't be on the edge with the mavericks. Be in the middle of the herd.
Yep.
Tip.
It's the safest place to be.
See you guys next week.
Thank you, guys. Jeff, thank you so much. Great information. I know we ran a little long. It's just a story worth telling. And sometimes investing time is way better than investing things you didn't want to.
That's right.
All right.
See you guys. See you next week.
Thank you, guys. Bye-bye.